Mr. Hanson, are you ready? Okay, thank you. State versus Struve. We have Kyle Hanson and Vidhya ready. Vidhya, you may begin. Thank you.
May it please the court. I am Vidhya Reddy. I'm here on behalf of defendant appellant Stephen Struve. On appeal, Mr. Struve seeks a new trial on his possession conviction on grounds that the district court erred in overruling his motion to suppress. Specifically, defendant contends that the district court was incorrect in concluding that the stop was supported by reasonable suspicion that Mr. Struve was using his cell phone while driving in a manner violative of Iowa Code Section 321.276, which governs the use of electronic devices while driving. Specifically, that Iowa statute includes both hands-on uses of cell phones that are authorized, as well as hands-on uses of cell phones that are not authorized. Given that nature of that statute, the officer's observation of Mr. Struve manipulating the phone while driving by tapping on it or swiping on the lighted screen, that did not give rise to reasonable suspicion of a statutory violation. In other words, the law enforcement officers certainly observed defendant using the cell phone in some manner while driving, but they did not have any articulable, reasonable basis for concluding that the use was for a purpose prohibited rather than permitted by the statute.
Other than the exceptions listed in subsection 2A, what would be an example of a lawful use of a cell phone in a car?
Other than the exceptions specified, I believe that's it. Other than hands-free operation, I suppose. But in terms of the hands-on operation, I think the exceptions specified in that subsection, control or are the exclusive means of.
So was Mr.
Call and GPS. And if he's not doing one of those two things, everything else that a motorist would be doing with a phone is unlawful. Is that correct?
And safety alerts, yeah, correct.
Are conceding, so was Mr. Struve violating the statute when he was looking through his phone?
If he was looking through his phone at the time, which he admits doing after the stop, then yes, it was a violation. But of course, the basis for the stop has to be evaluated at the point that the decision to initiate the stop was made. And so it's based on the totality of the circumstances that were observed by the officers prior to that point in time, at the time, that they initiated the stop.
So if he was violating the statute, wasn't there actually probable cause to pull him over?
Not based on the observations that were seen. So the fact that there is or is not ultimately a violation does not control. So in the same way that it doesn't control that, that an officer can have reasonable suspicion, but then it turns out there's not actually a violation, that doesn't mean the stop was not lawful.
Counsel, is it your view that officers could never pull anyone over they observed using a cell phone because the use might be legal, or would you concede there are some factual scenarios where what they saw would allow them to pull over?
I do concede that. I don't think this is a circumstance where there's absolutely no conceivable set of facts that could justify. 10
seconds, isn't that a long time to be doing navigation or starting a phone call?
I disagree. I think it's certain. I think that duration, number one, we make that factual distinction that he's holding the cell phone for 10 seconds, but he's only swiping for 5 seconds. That's what's supported by the video. There's no contrary findings or testimony. However, even assuming, 10-second active duration of swiping, I would submit that that is not, it does not indicate that it is an unlawful purpose rather than a lawful purpose. It's wholly explainable by, the fact that this, the statute permits, for example, inputting a telephone number manually. So, given how long it takes to input all those digits, doing it in a careful manner so that while you're driving, so that you're not, posing a danger. The same with navigation. The statute's permissible use of navigation is broad. Any sort of use is authorized of navigation.
Don't you think the statute was written because of distracted drivers as a protection to keep people safe out there?
Sure.
So don't you think 10 seconds of doing anything is there's a rational inference that would be an inappropriate use of the phone?
I don't. And the reason for that is because when we're evaluating whether there's reasonable suspicion for the stop, we have to do that in light of what is prohibited by the statute and what's observed by the officers.
I mean, U.S. Supreme Court in Illinois versus Wardlow said, Terry recognizes that officers can detain individuals to resolve ambiguities in their conduct and thus accepts the risk that officers may stop innocent people if they do not learn facts rising to the level of probable cause. An individual must be allowed to go on in his way. I can imagine that some language like this is in the training manual for these officers. Isn't that exactly what the officer here did?
To resolve the ambiguity, you mean? So the reasonable suspicion standard certainly has that purpose, and that's absolutely correct. But it doesn't mean that the mere possibility that the person might be engaging in unlawful conduct is itself enough. And
Well, it is kind of an ambiguity. I mean, I watched the video too. The driver is there with the phone. You can see the screen lit up, the thumbs on it. You don't know whether he's texting, showing photos to his buddy, which is what he said he was doing, which would also be against the law, or doing one of those two legitimate things that you alluded to. Why can't the officer stop to, in the words of the Supreme Court, resolve the ambiguity?
I think the difficulty is all that's known to the officers is that there's cell phone use. There's no indication, and the officers don't purport to suggest that, they had any sort of objective basis for, there was questioning about, the nature of the typing. Did it indicate texting rather than something else? And they said, nope, we could just see tapping, swiping, we couldn't tell. Well, it is, but so is the fact that, if a driver looks down, for 5 or 10 seconds or looks in the back, seat or something, does that mean that they're looking at an electronic device?
I don't know if there's a statute that says that just turning the head is violative, but there is a statute about phones, and the officer could see the phone. Isn't that different than your example?
It's certainly a closer question, I think, than the example. But I think the key point is that it's certainly true that reasonable suspicion is a lower standard than probable cause, but that doesn't mean that any suspicion of possible criminality suffices. And I would pull this court's attention to the specific cases that discussed in briefing, including, for example, Tague. Tague said, that was the case where there was a momentary crossing of the center line, right? And Tague said that that's not itself, number one, a statutory violation. So in the same way that merely holding or even tapping on a cell phone is not itself a statutory violation. It's not a traffic
Counsel,
offense.
Is there anything in this record that gives an indication of when people use their phones, what percentage of that use is the unlawful conduct versus lawful conduct?
There is not, correct.
And do you know if there's any difference based upon age? For example, does a teenager perhaps text more than an elderly person?
We don't have that information in our record. Correct.
In the absence of that information, is it enough for the officer here to rely on his common sense and observations? And I'm thinking specifically of the Glover case. The courts recently made clear that reasonable suspicion is a fairly low threshold. I mean, I know you said it can't be some scintilla of suspicion, but it doesn't seem like it requires much more than an ambiguity as to whether the law is being violated. Is that fair?
I disagree, and perhaps part of it, is related to how we define an ambiguity, right? I mean, the fact that someone's in a vehicle driving down the road means that they might, they might be engaged in some kind of criminal activity. They might have, paraphernalia in their vehicle. Drug drivers drive cars, or drug users and dealers drive cars, right? So the mere fact that someone is using a cell phone, I don't think that itself arises to the level of ambiguity of criminal activity, right? It's not enough that you have reasonable suspicion of cell phone use. It has to be of unlawful cell phone use. And there has to be some kind of articulable fact that the officers point to that indicate.
Given the way that our statute's drafted compared to the other cases that you cite in your brief, this seems much more comprehensive in terms of the conduct it prohibits. I mean, we talked about it. You can name 2 lawful examples of phone use, GPS and pressing the buttons to make a phone call.
And safety alerts.
Everything else is unlawful.
That's right, but I disagree that that's, inherently broader. So, for example, I would point to the FOM case cited by the state, the Oregon statute. In a sense, that statute is much more comprehensive than the Iowa statute because of the fact.
And Oregon is a good example. My question for you is, what additional would it have taken? In Oregon, there's 2 cases. One of them, they couldn't see anything, any movement in one case, and so that there wasn't reasonable suspicion. But in the other Oregon case, it was enough that they could see movement by the thumb manipulating the case, or manipulating the phone. What additional facts would the officers have needed in this case to have risen to reasonable suspicion?
So in the Oregon case, the one where the one case involved, the fact that they couldn't even tell that it was a cell phone versus something else, right? So it doesn't reach the question that we're concerned with here, which is what circumstances warrant a conclusion or reasonable suspicion of unlawful use, right? So the other case, the FOM case, the key additional fact I think that was there is the fact that there was some kind of movement indicating consciousness of guilt, some kind of furtive behavior after law enforcement, approached the vehicle that indicated the driver may have, known that his use was for an improper purpose and therefore.
Kind of like in this case?
I'm sorry?
This case?
Well, there's no furtive movement that's pointed to. And again, we've got to focus only on the only universe of facts that we can look to when we're looking at reasonable suspicion is what officers observed before the stop, not after.
I think if,
So you believe that unless Mr. Struve would have seen the officers and put his phone down quickly, some kind of furtive movement is what needed to be done. That's the only additional evidence that would support reasonable suspicion by the officers?
No, I think there's a number of grounds, and a number of them are listed in my reply brief. But I mean, for example, if the officers heard something through an open window indicating what use it was being put to, if he had a history of improper use, he had prior violations of the statute, or if, and you can even imagine, for example, pulling up next to someone, at a traffic light and seeing them, manipulate their phone in a manner that does make it clear to you. There's no indication that there is any sort of, number one, just factually, the officers don't purport to say that, I think he was using it for an improper purpose rather than a proper purpose given X, Y, or Z.
When they walked up to the car, they told him texting while you're driving is illegal.
They did, but at the suppression hearing and in the testimony that's given, they acknowledged that they couldn't tell from the manner of the swiping or any of the manner of use, what any indication whether it was being put to an improper or a proper purpose, right? All they see is typing or swiping, and I would, I'd call the court's attention, for example, to the Krebs case in Iowa, where it discussed, flight, and to this court's questions about, resolving ambiguity, right? So flight can be one of those things that can indicate unlawful conduct and give rise to reasonable suspicion, but it doesn't always.
Excuse me, wouldn't your argument be a little stronger? I want to go back to Justice McDonald's questions about the exceptions. If I saw a phone on the dashboard and maybe there was a little bit of movement, that might indicate perhaps GPS use, or up to their ear, or punching in a quick number. But wasn't there much more than that? 10 seconds of not doing either of those things in this case?
I don't think so.
I'm struggling with the question that Justice Oxley asked you too. Furtive movement only Really?
No, I don't think it's furtive movement only. And like I said, I think there's lots of circumstances that can warrant those additional facts. I mean, even if these officers testified that based on their training, you know, this set of circumstances where someone's using or manipulating their phone for more than 5 seconds or for more than 8 seconds, it's typically for, or, you know, it's more likely to be for an improper use. There's no kind of specialized testimony, training, anything. All these officers testify to is the fact that an individual is, you know, using his phone, and that's not an unlawful use. That's not something that's prohibited. And I
Counsel,
think,
are you bringing your claim only under, I know you've asserted both the federal and the state constitutional claims, but are you suggesting that we apply a different standard under the state constitution than the federal constitution?
there's no specific separate framework that defendant is suggesting. Certainly,
Okay, so are you aware of the Glover case that Justice McDonald mentioned?
I'm
It was a
not.
recent case that the Supreme Court just came out with this spring, and it's pretty broad.
So what I will say is I'm not, you know, we haven't asserted an individual or a separate framework, right? But Iowa has interpreted that, you know, the provision more narrowly under the Iowa Constitution. And for example, specifically in, I think it's the Tague case, I mean, specifically their holding of no reasonable suspicion
You can wrap up
rested.
quickly.
Oh, I'm sorry. Rested on the
you'll
Iowa
have a-
Constitution.
Your point about flight, how that can be, yeah, go ahead.
Yes. So in Krebs, you know, this court took care to say, you know, flights is something that is significant in this analysis, but it has to be flight in a circumstance that indicates that it is because of consciousness of guilt. So you have to have a circumstance where officers observe that as they approach and become visible or apparent to the individual, at that point, the flight, you know, occurs. You know, and so in Krebs, that was satisfied. But if there's not that circumstance, for example, the mere, you know, existence of flight, even though it can be deemed ambiguous, you know, that alone is not enough to get you to reasonable suspicion. And so similar here, you've got to have other circumstances that indicate, you know, that this is meaningful as a, you know, under the statute. So, thank you.
Thank you.
May it please the court, and Justice Appel, can you hear? Okay.
Yes, thank you.
Good idea.
Position would preclude any reasonable enforcement of this code section. It would require an officer to actually see what was on the defendant's phone screen. It would require certainty of a violation, and that is not consistent with the reasonable suspicion standard. It's a standard.
What do you make of Judge Posner's Seventh Circuit opinion? I mean, he basically, and I'll summarize it briefly. I mean, he kind of says, well, there's reasonable suspicion of cell phone use, but there's lots of innocent explanations. And he kind of goes on to say that if you could stop anybody with a cell phone, it would be kind of equivalent of a general warrant that would be subject to arbitrary enforcement and abuse. And I guess he concludes on the facts presented there that there was not a sufficient basis to make the stop. If we follow that opinion, do you lose, or can it be distinguished?
It can be distinguished. It's different in Iowa based on the language of our statute. And unlike the Indiana statute at issue there, which only targeted texting, Iowa statute is much broader. It starts with the proposition that any image visible on the screen is a message, and it's precluded. And then it delineates very limited.
But phone use is it basically allows phone use. You can type in, push in, thumb in, whatever. That's permitted. That's the basic purpose of a cell phone is to make phone calls. Although, our smartphones do other things, I understand. But the function of placing a phone call is really quite common. And then the use of GPS is it's not rare. Dare I say, just about everybody uses GPS at some time. Wouldn't you agree?
I agree that GPS is a use that people have for cell phones in a car. However, if you look at the facts of this particular case, Mr. Struve's usage was not indicative of GPS use or placing a
Oh,
phone call.
well, but why not? Because what the cop knew, and correct me if I'm wrong, so the screen is illuminated. Seems to me that might be a period of 5 seconds when he's kind of scrolling his thumb. But that's consistent with GPS use. I mean, you try and figure out where you are. You try and figure out where you're going. The map isn't always well suited. Sometimes you want to try and zoom in and zoom out, and you're fooling around with your thumb on the GPS.
So I think just common usage of navigation while driving doesn't involve holding the phone out in front of your face the entire time. Usually if somebody's using it for that, it's secured to the dashboard in some manner. It's not held in the hand the entire time.
It's in this record about the percentage of use that was for unlawful versus lawful purposes.
There was no evidence presented. I tried to find statistics. There's some statistics out there about the percentage of drivers who use their phones for certain purposes, but I don't think anyone's undertaken a study to try to determine 50% of phone usage in a car is this usage versus 10% this usage.
Drinking alcohol while driving is unlawful, right?
Right.
If I'm driving and I have a cup that the officer can't see through, could the officer pull me over on the belief that there might be alcohol in my cup?
No.
How's that different from this case?
The difference is that the texting statute, the cell phone use statute is much broader. It's kind of the difference of if the statute only precluded drinking Diet Coke while you're driving and every other beverage was allowable.
You just told me that you don't know what percentage of use of cell phones is lawful versus unlawful. So I get your example that Diet Coke might be a small percentage of drinks, but I don't think we have any evidence in this record that indicates what's lawful versus unlawful use of a cell phone, do we?
General knowledge that a cell phone is capable of doing many, many, many tasks. And under Iowa statute, all but very limited uses are permissible or impermissible. And just the fact that maybe he was using his phone to adjust the map, maybe he was taking an extra long time to dial a phone number, those are the sorts of ambiguities that the officer is entitled to clear up with a stop and a reasonable investigation.
So anybody using a cell phone in a car is subject to stop? Is that your position?
No, it's not mere usage. It's the circumstances that these officers observed. It's holding the phone out in front of his face. It's moving his finger around.
Of eyesight? I sometimes hold things out because my vision close isn't that great.
But not while driving. And my point is, somebody using it for navigation, as counsel suggests, is not going to be holding it out in front of their face the entire time. And there's a remote possibility that this just happened to be the moment he picked up the phone to do something. But again, that's an ambiguity that can be resolved with a stop and reasonable investigation. And the problem...
Well, I guess an officer who runs a plate and sees the registered owner of the vehicle is barred or suspended from driving, but they can't see who's driving. I think we'd all agree that it's a valid stop to pull them over and see if it's the barred owner or somebody else. If it's somebody else, then they're on their way.
That's the key with the reasonable suspicion analysis, that it can be a stop and investigation is authorized even if the conduct turns out to be wholly lawful. And if we look at the seminal case, Terry v. Ohio, the conduct there was window shopping. In Krebs, it was driving slightly fast in a circle. Now, certainly those could be indicative of innocent behavior, like looking for an address, or in the Terry situation, they're just shopping and looking through the windows. But that's why the officers get to act, is to clear up the ambiguity and figure out
What are we to make of the bouncing back and forth in his own lane? Does that matter here?
It does matter to the extent that it shows he is distracted from driving. It shows
Be distracted by using his map app?
that is true, but the point is that texting while driving, using your phone while driving, is a dangerous activity. It's second only to drunk driving in the number of crashes and fatalities. So the fact that he is weaving back and forth gives the officers in this case a heightened need to stop and investigate what is going on. The ultimate problem here is that if these officers were not authorized to stop Mr. Struve, there's no officer who would be able to stop somebody for texting while driving.
Posner makes short work of that. He said that the problem then is with the statute, and you ought to have a statute that prohibits broader cell phone usage.
Yeah, and
Right.
that's a peculiarity that the legislature could make a more restrictive statute to somehow make the stop legal. That doesn't seem consistent with the constitutional right to freedom if we are forcing the legislature to further place limitations on cell phone use while driving. The other option is that officers just stop enforcing this code section, which again it's designed, intended to cut down on a very dangerous driving behavior that deserves enforcement.
If we follow Justice Scalia, the nature of the crime doesn't matter. He says, well, for search and seizure purposes, we don't look instrumentally at the underlying crime. We look to the principles of search and seizure and apply them equally, no matter what the crime. Is that the approach we should take?
I guess I'm not sure I quite understand the question you're asking.
Yeah, the question is whether or not, I mean, the public interest in the enforcement of some law, whether it's major or minor, is not something that Scalia would be worried about in trying to analyze a search and seizure problem. He's more interested in the exact nature of the police conduct. In other words, the search and seizure law doesn't vary by crime. It's the same for all crimes. Do you agree with that?
No, I would push back against that. And I think, for instance, imagine a situation where there's a murder that happens down the street and somebody sees a blue car leaving the scene this direction and a police officer sees a blue car coming that direction, versus somebody observed a blue car speeding down the street and the officer sees a blue car now. I think there is a heightened Fourth Amendment interest in allowing the officer to stop for the murder versus the speeding, just based on the severity of the crime and the danger to the public that's presented by having a murderer versus a speeder.
So there is no real search and seizure law. It all depends. It's all crime specific, and there's all kinds of gradation of crimes, and we have a different search and seizure law for a felony and a different search and seizure law for a misdemeanor, and then there's an aggravated misdemeanor, and then there's habitual offenders, and then there's Class A and Class B and Class C, and for each category we have a different search and seizure law.
No, I think it's something that factors into the reasonable suspicion analysis, and it's something that this court has said in the past in Krebs and previous cases that a good test for determining whether reasonable suspicion exists is whether we would question the officer's fitness for not stopping under the circumstances. And the severity of the danger of the violation is something that can factor into that analysis. So for those reasons, the state asks that this court interpret Iowa Code 321.276 in a manner that keeps it enforceable with reasonable stops based on observations of illegal cell phone use while driving, and affirm the conviction. Thank you.
You're ready.
May it please the court. I want to start, with this notion that the Iowa statute is inherently broader than all of these other statutes. And what I would point this court to is, again, comparison, for example, to the Oregon statute. Because the Oregon statute is in one manner quite a bit broader than the Iowa statute. So that statute prohibits any sort of communication with the telephone, including not only, voice communication, but also, or not only text communication, but voice communication. And, a voice communication by cell phone, including by typing in telephone numbers or names while an individual is driving, is both authorized by the statute and is, I think, something that is inherently common, a common use to which it's put. What I would suggest is in particular, for example, you could look to the Oregon statute has since been amended since the case law that the state cited. And they've since adopted a hands-free statute. So in terms, our legislature has other options if they want to authorize more stops or increased enforceability of this type of statute.
Counsel, what are we to make of the bouncing back and forth within the driver's lane? Does that matter at all to this stop?
I don't think it does. Well, I think the biggest issue with that is the factual issue, which is that one of the two officers says there's bouncing, the other says there's not. The officer that says there is bouncing says it's not, in itself a violation. It wasn't itself concerning. The district court doesn't find it, any bouncing. No bouncing is visible on the video. But I think from a legal perspective, the reality that it's bouncing in and of itself, isn't a violation. Now, certainly, the manner in which the vehicle is being driven can be considered in the totality of the circumstances with the operation of the vehicle or with the operation of the phone. But I think certainly, the degree of distraction that might inherently...
Counsel, is there any evidence that there's more bouncing back and forth if you're text messaging as opposed to using a GPS app or punching in a phone number?
That's exactly it, is that there's, to the extent that it could be a factor that indicates some sort of distraction, that itself is not enough, absent that sort of additional testimony or a greater degree of egregious behavior, I would say, at minimum, than what's at issue here. This is not a distracted driving statute. I recognize that that's a purpose, that motivates the enactment of these types of statutes, but it's not itself a distracted driving statute. It doesn't prohibit any and all distracted driving. It prohibits a certain type of cell phone use, and there's no articulable fact that the officers could point to that gave rise to reasonable suspicion, not just of cell phone use, but of prohibited cell phone use.
Should we question, or would a reasonable person question this officer's competence if they had not pulled over this driver who they saw, holding a phone in front of their face for 10 seconds and manipulating it during that time?
I don't think so, and not under our statute. Again, so the amended Oregon statute, for example, says, any holding of the cell phone is a violation. It's not limited to permitted versus impermissible uses. So given, the language of our statute and what it authorizes or what it prohibits, and the fact that what it permits is, our uses to which cell phones are routinely and commonly, put just in general knowledge on the roads, and absent any sort of this other testimony about, actually most cell phone use is for an improper purpose or anything like that. I don't think that those are the key considerations that are at issue. I also wanted to go to, I know there's been some, discussion about, placement of the phone on the dashboard versus holding it, for example, GPS navigation. I would, I guess, disagree with the conclusion that it's only placement on the phone, or usually GPS is by placement on the dashboard. But, more key is the fact that there's no testimony about that. So the officers don't say, in Iowa, either statistically or in our practice or training or experience, usually when people...
Is that necessary for reasonable suspicion? And if that's your position, I guess, how do you square that with Glover, where the court was wrestling with that issue, the lack of empirical evidence relating to the probability of person, the registered owner of a vehicle whose license is barred. And there was no evidence of that in that case. And the court said, well, we can rely on kind of common assumptions. And
Okay.
a common assumption here, most of us have phones, we understand how they're used, we can see the videotape, that somebody who holds a phone out like this for 10 seconds isn't making a phone call.
I think the problem is that I guess I disagree that it's a common assumption. Just looking at, that might be your experience perhaps, but I would suggest that that is not the norm of, that if you're holding it, that you're not using it for GPS or for placement of a phone call in a careful manner when you're driving. And I think that's really the issue is what's prohibited is or what's allowed is so much broader and so common of uses that in this circumstance, we've got to have something additional. Whereas I think it's intuitive that, typically, given the value of vehicles to individuals and all that, that usually the person driving the vehicle is the registered owner rather than someone else, and that you can proceed on that assumption until you find something to the contrary. And the flip side of the state's position is that anytime someone's using a cell phone, while driving, that authorizes a stop, even though there is this broad category of common uses which are permitted under the statute.
You may wrap up.
With that, defendant requests that he be afforded a new trial. Thank you.
Thank you. We are going to take one more, just a quick break without leaving the bench for the transition. Thank you, counsel. For the next case, I need to let you know, if you weren't in the room earlier, we've been having some technical difficulties. Applicant will remain seated and speak using the microphone right there on the table. Appellee's microphone over on their table is not working. We're having Appellee approach the middle bench for argument. So as soon as we're done getting things sanitized, we will allow the next case to come forward.